being live streamed on YouTube and recorded. We'll go ahead and get started with the first case. It's 24-0855, Allstate Property and Casualty Insurance Company versus Carlos Diaz. Good morning. Can you tell me how much time you would like for rebuttal?
6 minutes, Your Honor.
Minutes. Okay, and you may proceed.
May it please the court, Kevin Franz on behalf of Allstate. Allstate was denied the right to a fair trial based on plaintiff using cancer as both a sword to evoke sympathy from the jury and a shield to prevent Allstate from discovering relevant evidence. As to the shield, the plaintiff injected his cancer into this case at deposition, testifying that the reason that he didn't treat for his neck and back for 2 to 3 years was due to treating for cancer. The plaintiff then successfully prevented the defendant from obtaining records related to cancer, arguing they're clearly irrelevant and had no bearing on the motor vehicle accident. But these were relevant for several reasons. First of all,
Did they prevent your client from getting the records? As I understood, the request was block the records request or do an in-camera review. And I didn't see anywhere in the record where Allstate followed up and said, we want the in-camera review, do that.
we had a hearing on the motion for protective order, motion to compel. Plaintiff's counsel said, I have 2006 records, which all relate to cancer. This has to be done via in-camera review. The defense argued we don't know what's in them. We're entitled to have the court look at them and determine what is in them if they're relevant. The judge said, I'm going to take this under consideration, reserve ruling, and then it entered a clear order denying the motion, compelling the records, saying that these are irrelevant and they are protected by the privacy rights of the Constitution.
But the records that were withheld, was there any follow-up request where we want an in-camera review on the ones that were withheld?
There was not a request after there was a definitive ruling written by court order saying these records are not going to the defendant, period. So there was no need for a follow-up because this was preserved based on that written order. These were relevant to, of course, verify and impeach whether what the plaintiff said in deposition was true or not. That's why in every personal injury action, you obtain records to determine whether or not what they say is accurate. The plaintiff says is accurate. Additionally, to see if there was any physical exams during these 3 years of treatment for cancer that may have discussed, oh, I'm having a tremendous amount of neck and back pain, or I'm having zero neck and back pain. The trial court abused its discretion in precluding this because cancer was placed at issue. And this court in Value versus Nevado, just from this year, an issue, the court agreed that the plaintiff waived the constitutional right to privacy and medical records relevant to the claims. What's interesting in that case is the claims in that case were for the neck and back, same as here. What's interesting about that case is that the records at issue were dental records, something you would not think would be particularly relevant to the neck or back. But in the court's opinion, it said that people will have discussions with doctors about all their aches and pains, giving the example that dentists can also indicate when you're having neck pain. This is exactly what we needed to see to verify plaintiff's complaints. And I do want to mention that there was a petition for writ to obtain these records to the 5th DCA. That court simply dismissed the case for lack of jurisdiction, finding that we did not establish irreparable harm. All that means is that the issue can be addressed on plenary appeal, which is what we're doing.
Well, and the 5th said that you could get the records from other sources, correct? Did you do that?
It said that it denied the petition because we didn't establish that we could not get the records from additional. It didn't say you can go ahead and get records from additional. But the bottom line is I actually disagree with that, because the only way you can know what's in these records is to actually get these records. There's no other source that we could go to learn that. And the plaintiff then used this as a sword at trial. Now, what's ironic is that the plaintiff was the one who moved to exclude all evidence of cancer in their first motion in limine at paragraph 35, and the 10th motion in limine sought to exclude evidence and records regarding prostate and thyroid cancer treatment or illnesses.
So at trial, we don't have the opening statement in the record. Is that correct?
Correct.
Okay, so I noticed in closing argument, Allstate did argue, well, if he was really in that much pain during those 2 years, then he would have sought treatment. So I don't know if Diaz made that an issue, Mr. Diaz made that an issue in the opening statement because we don't have that, came up during the trial, but it seems like Allstate did bring it up, at least in the closing argument I saw.
Well, the plaintiff obviously closed first, and I will get to that and quote from the closing. So the plaintiff raised that. If the court reads the transcript in its entirety, I'm not even sure that the defense mentioned word cancer more than 1 or 2 times the entire time. The plaintiff, however, used this about 48 times. Now, the 2001 thyroid cancer has absolutely no relevance in this case if that was discussed at trial. And the 2000 prostate cancer has limited relevance, maybe to one time explain the gaps in treatment.
But I think Judge Wozniak's point is if you argue, hey, there's this 2-year period that they didn't seek treatment, the natural response to that is we had a reason to not seek treatment. We were dealing with some other more serious issue, right? And so, once assuming you open that door, and like I said, we don't have the opening, we just have the closing, and I know that creates a distinction. But once you open that, it's not like you say, well, we open the door, they only get to say it twice and not 48 times, right? Like if you open it, you open it.
And the problem is that we were denied discovery on this relevant issue then. If cancer is a relevant issue and before trial started, the trial court judge, who was different from the initial judge, denied our defense counsel did not remember that cancer had been excluded from trial based on written orders. And when he raised it, he remembered that it was her, but he didn't remember the ruling. And he argued that this was prejudicial and irrelevant. And the new trial court judge simply said, this is not timely, I'm denying it. So that, we did not open the door to this coming in. The trial court judge allowed this to come in.
Well, I mean, you asked the trial court to address the issue. Now, granted, it seems that was clearly under, your trial counsel misremembered that there was already an order in place. But nonetheless, your trial counsel did raise it, asked the court for a ruling, even though there was already a limiting order in place. So you tell the trial court there's no order in place. And so it looks to the trial court like your motion is a new motion that you just didn't get a timely ruling on. Trial court denies it as untimely. Is there no part of that that's on your trial counsel?
There is some, but I would suggest there is some on opposing counsel.
Because in your briefs, you said it a few times, like Diaz's trial counsel should have stood up and corrected him. Well, I'm not sure what rule would have required them to do that. B, that kind of assumes they remembered when you didn't remember, right? Like you're not you, but your trial counsel, right? I mean, we can't get in their head and know what they were thinking when your trial counsel raised this issue. So in my mind, you ask the trial court to adjudicate an issue, you're kind of opening the door to that being adjudicated or re-adjudicated at that time. And no one else did that. It's not like they said, Judge, we want to revisit this. Your trial counsel did that.
I do think candor to the court, and I can't get into my.
But if your trial counsel didn't remember, how can we assume they remembered? Like, how do we know what was going through their head at that moment in order to say they had a duty of candor to the court? And how do we know they've interpreted your request as knowing there wasn't why would they assume you didn't know there was an order not in place as opposed to you're asking the court to revisit it?
And I concede that, Your Honor. I think the main point is this is an auto accident case about neck and back injuries, and cancer became the absolute focus of this case. So I think this court can look and see, was this verdict based on sympathy, based on the focus being of cancer? Now, if Your Honor is correct and says, look, you can explain the gap in treatment one time, or you don't even have to use cancer. You can say due to an illness or whatnot. But if we can't get the records, if cancer is relevant to this case, we are entitled to the records to determine whether or not they substantiate the plaintiff's claim.
Well, I mean, imagine this turn of events. You don't get the records, okay? But then at trial, you're the one, at least we know what happened in the closing, that says, hey, there's this 2-year gap. So now an issue which you didn't get records on, but which might not have come in, right? You also had an order prohibiting anybody from talking about it. You then ask the judge to re-examine the issue at trial, way past the discovery issue, re-examine the issue of whether this is going to be admissible or able to be talked about, and B, give them a reason to talk about it. Because you say, Jay, there's this 2-year period where they didn't get any treatment.
I think the problem, though, is I could not be here making this argument if there was one line of testimony where the plaintiff said, I couldn't get the treatment because I was there for cancer, because I was treated for cancer. But here's the plethora of evidence that caused a runaway jury verdict in a simple auto accident case to award more than the plaintiff asked for. Carlos Diaz. This goes to way more than just explaining a gap in treatment, testifying that he agreed he was full of life until he was diagnosed with thyroid cancer. Surviving cancer changes the way that you look at life. You see things differently. Having survived cancer earlier, he was asked 20 years earlier, how did you approach prostate cancer the second time you had to deal with it? The second time was hard, but this is my prostate. This has nothing to do with gaps in treatment, by the way. This is just done to evoke sympathy from the jury. Even counsel had to tell him this was obviously extremely emotional. Counsel even had to just say, quote, just take a deep breath. And then we get into COVID, where he was testified that he was immunosuppressed because of cancer. He got very scared because of that. This goes way beyond explaining very briefly that cancer caused me to not treat for my neck and back.
That goes to my point, like how, if a door is opened, is it only open for some narrow extent? Like what would be, how would we draw that line that says, all right, if you open a door, they get to bring it in, but only a little bit. But how would we decide how much they get to discuss something that you've opened the door to? And what would be the standard we would apply to determine that?
I wouldn't agree that the door was open. I don't think that the defense did anything to open the door. In fact, it was the only reason this even became an issue because the plaintiff testified in deposition. The reason that I didn't have this was the reason I didn't treat for 2 to 3 years for my neck and back was because of my.
Do you
my
contest
cancer.
Judge Wozniak's characterization of the closing that your trial counsel said there was this 2-year period?
Maybe in rebuttal, but I'd like to actually, but that's not opening the door because the plaintiff went first and said, Mr. Diaz has had some hurdles in his life that he didn't ask for. 2 bouts of cancer, survived one by more than 20 years ago, another one just 2 years ago. Those have nothing to do with this case, although it's been discussed. He has overcome those things, but life says that if life's events, through no fault of your own, bring you to living your life on the edge of a cliff, then this trial is about what did it take to push someone off that cliff. This trial, the focus of this trial should have been on what did it take to push him off this cliff. So that had nothing to do with this gap in treatment.
But I think the phrase was though, we know you said in your closing, and granted, they said some things first. We don't know what you said in your open.
In opening
Right.
statements, which
Yeah. So what if your counsel had said the same thing in opening as they did in closing?
based on the totality of the entire record, when defense counsel maybe said the word cancer once or twice, it's hard to believe that he would have said this has to do with pushing that cancer affected this person so much that this accident is what pushed him off the cliff. Plaintiff's counsel combined cancer, which has very little to do with this case, to basically said that gets him to this point, just at the edge of the cliff, and this auto accident pushed him over. This case is not about cancer, but it was made about cancer. If cancer was relevant to some extent, it was an abuse of discretion in precluding us from obtaining discovery records related to cancer. And if it wasn't relevant, then it was abuse of discretion in admitting this evidence. The combination of allowing cancer to become the theme at trial while preventing the defense from viewing records deprived Allstate of a fair trial. We ask the court to reverse and remand.
Can we move on to the bias of Dr. Mahan issue? Just before you sit down, I do have a question on that.
Yes.
Okay, so if we were to find that there was error there in not allowing the question about Dr. Mahan being in opposing counsel's wedding, there's the harmless error issue. Special West Boca, that case says that the appellee is supposed to address, it's their burden on harmless error. My reading of the answer brief is that it was not addressed in the answer brief. What do we do at that point? Do we have to sua sponte, analyze harmless error? Did appellee waive that issue? What do we do with that?
Appellee waived the issue. If we raised the issue in our initial brief, and it's, as you said, it was error, especially under the McKinney-Graham case, which literally this exact issue happened in. And if they don't explain, it's their burden under Special versus Boca. They have to prove that there is no reasonable possibility that that could have led to contribute to the verdict. It's not our burden to do so. And very briefly, this court very briefly issued the Geico versus Ibarra's decision very recently on that it is an error as a matter of law to enter a judgment over the policy limits, absent of bad faith. This court needs to follow that, as this court has already issued that opinion. And the judgment in this case has to, at minimum, has to be reversed to limit the judgment to the policy limits. Thank you.
Morning, judges. Jeffrey Bird. I was trial counsel and I'm appellate counsel. I want to begin by saying I have a duty of candor to this court as well. And with respect to his citation to the VAR's decision, he's accurate. So therefore, I have to concede that with respect to the judgment that was entered by Judge Schreiber, who at that time did not have the benefit of the VAR's decision that just came out 2 weeks ago, that this court should remand with instructions to enter a judgment consistent with the VAR's decision. Now, I want to be clear. Judge Schreiber made a ruling based upon the only case that existed at that time. So I don't think it was fair to characterize Judge Schreiber, who's a very experienced judge, as having committed error when she was following the only case that existed at that time, which was the Walker decision. However, I understand that you must make a decision based upon the current state of the law, not as it was back then. So while I did concede in the brief that this panel might do that because a case called Finson came out from a different DCA, I now have to acknowledge and concede that this court, it's not a final decision, so it's not technically binding, but I don't want to split hairs like that, that the VAR's decision does appear to suggest that this judgment was entered in error, not because Judge Schreiber didn't correctly analyze the law, but because the law has just simply changed or has been refined, let's say. It is curious to me why no DCA, now 3 DCAs have called into question the 4th DCA's decision of Walker, and nobody has certified it yet to the Supreme Court, this conflict, but there's a whole discussion about dicta that I'll bypass for purposes of this oral argument. So, duty of candor, I do acknowledge that as to that limited technical issue on the entry of the judgment, that the court should remand with instructions to follow the more recent VAR's decision. However, as to all other issues, neither Judges Weiss nor Judge Schreiber abuse their discretion in any respect. With respect to Judge Mize, your question, Allstate did not at any point over a period of years ask for an in-camera inspection. This notion that the plaintiff asked for an in-camera inspection is specious because why would I ask the court? I'm the one that withheld the records. I complied with an order that was entered by stipulation that said if records were obtained that violated my client's constitutional right of privacy, that I was permitted to withhold them, give notice to Allstate, which I did, give notice to the court, which I did. We held a hearing, lengthy debate and discussion, and this notion that I somehow argued that the court should have reviewed 2,006 pages of cancer treatment records. It all related to my client's prostate. And I think all of us could understand why one would not want that type of information put out in a public domain. They didn't ask for an in-camera inspection. They didn't ask for a special master. They didn't ask for anything. In fact, they did nothing after Judge Weiss entered an order saying, well, I'm not going to let you get the records, but you can get the information by other means. And they did nothing after they appealed to then 5th DCA, it was the binding appellate authority. They did nothing after the 5th DCA issued a decision saying you can obtain this information through other means. They literally did nothing.
Counsel,
until, yes, sir.
if Allstate had asked for an in-camera inspection, would the trial court have been required to do that, to perform that inspection to satisfy their curiosity about what was in those records?
I believe that a new decision from this court, Dominguez and Value, would affirm that position, yes. But I also think that the record bears out that I would not have opposed that. In fact, they're suggesting that I told the court it had to do an in-camera. No, I suggested that the court could remedy this with an in-camera if it deemed it necessary. But they never advocate. You know why they didn't advocate? Because Allstate's counsel multiple times said he knew that my client had cancer. That's borne out by the record. Also, dozens and dozens of medical records were put into evidence at trial that referenced by way of history the cancer. So this notion that I wrongly interjected cancer, respectfully, he read my client's testimony from trial, but what he didn't read was that they had asserted any objection to that testimony at trial. They did not. He also correctly read my closing argument, but what he didn't read is that they had asserted any objection to that closing argument at trial. They are the ones that created this defense, stating that my client only treated for 3 months following a crash and then disappears for 2.5 years when there was a very legitimate medical reason, which was both cancer and COVID. By the way, we haven't really talked about COVID, but because of my client's comorbidities at that time, it was a big deal. COVID, I don't want to get too dramatic here, but people who had the comorbidities were the ones that were passing. Ironically, Mr. Diaz ended up getting COVID, notwithstanding his efforts to remain isolated, and was hospitalized for the COVID. So those were very credible explanations for the gap of treatment that Allstate was attacking their own insured to say your injuries aren't as bad as you would have portrayed them to be, because you would have surely gone back to a doctor for neck and back pain if you had been in pain during that 2.5-year period of time. So with respect to all of the other remaining issues, I am making the concession as to the judgment. I feel like I'm duty bound to do that, but I don't believe that any other rulings were made in error. There has not been
Let
a
me ask you about the
preservation.
bias issue because,
Thank you.
it seems like there's two rules in the federal, in the Florida Rules of Evidence on this that say you get to ask questions about bias. You got 9068-2, you got 96082, you got 9612 subsection 2. Both say you can attack witnesses for bias, you can cross-examine them for bias. So in order for us to conclude that it wasn't error to prevent them from asking about your relationship with Dr. Mahan, would we just have to assume that being somebody groomsman 10 years ago is just too remote for a jury to possibly conclude bias? Like, how do we not find that error?
Thank you. That's an excellent point, because I do believe that remoteness at some point in time becomes a factor. But they also cite the Graham versus McKinney case, which is my case, where that judge, DCA judge, put in the decision that when you retain an expert, that you open the door to that type of inquiry. That Graham versus McKinney.
I saw that distinction in the briefs about the expert and the fact witnesses, and it just makes no sense to me at all, because either 96608 or 9612 make any distinction between expert and fact witnesses. It says a party, including the party calling the witness, may attack the credibility of a witness by showing that the witness is biased. Doesn't say only experts, doesn't say only fact witnesses.
So as to that issue, I think the distinction then is what truly defines a trial judge's discretion? Because the argument that they were advancing relating to him being retained expert, which, by the way, this proffer came after the testimony has already been presented to the jury, after Allstate's counsel has told the jury that he too, his law firm has retained Dr. Mahan as an expert witness. How Mr. Bird, me, has had Dr. Mahan testify as a treating doctor in other plaintiffs' trials. So the issue was before the jury with respect to
So
bias.
that's contrary to our precedent. So we have a case called Middlebrook, where we just say like evidence of bias based on one reason is not a justification to exclude a different evidence of bias, right? Like each piece of evidence of bias stands alone, because the jury might think one shows bias and one doesn't. So just being able to say, hey, we're friends, or we had a relationship, or we've hired him for other cases, that's not a substitute under this court's precedent for being able to give one specific piece of evidence of bias, which in this case would have been, he was your groomsman. And so to just say, well, other evidence of bias was before the jury, it doesn't say you get to show some bias, but not others. I mean, the rules say you get to show whatever bias is there, and that's what our court said.
Well, I do think, though, that remoteness is a factor. I do think that the record will bear out that judge.
It's a factor, but that's what I'm saying. The rules say you get to attack the witness for being biased. They say that. Two different rules, clear as day. So is the only way we can rule for you on that issue is just to say this was so remote that no jury could possibly think this was bias? Like, is that the conclusion we have to reach to
Well, and I think that
Rule in
there's
favor?
a multitude of other factors. Number one, there was a motion in limine on that issue that was filed, that was granted. Number two, that motion in limine referenced other legal authority from the Florida Supreme Court relating to the constitutional right that experts have as to their own privacy and their personal life. We have the Rule 1.280 that confines and restricts the scope of expert witness discovery. I do hear you, and I do understand that bias is in a different category. But when the Florida Supreme Court has curtailed that which lawyers can do with respect to experts, and specifically has identified that some discovery or cross-examination can result in a chilling effect, in that people who need legitimate doctors can no longer retain those doctors or have those doctors treat them, because the chilling effect that has been created by this personally invasive examination. Dr. Mahan actually testified specifically at the time of the proffer that this whole continued discussion and debate with respect to his personal matters has had a chilling effect. In fact, I think he even used the express words chilling effect, that he said, I'm no longer friends with Mr. Byrd and don't socialize with him because lawyers like you keep bringing up my personal life. So I think.
Counsel, I
Yes, sir.
want to ask you on that point. You cite the discovery rule and case law that I think deals with the invasiveness of expert discovery. But if everybody knows that Dr. Mann was a groomsman in your wedding, it doesn't require discovery to get there. Why is that, necessarily off limits and cross-examination? I think you make the point in your brief that if it's not discoverable, then it's also not subject to cross-examination. But I don't find any support for that. I mean, if everyone knows he was your groomsman, they didn't have to get that information through discovery. Why can't they bring that up? Because the admissibility of bias evidence is completely separate from the discoverability of X, Y, and Z for experts.
So you were anticipating my response, which is if it's not discoverable, it's not admissible. But at some point, trial judges are there to monitor the situation at hand as things are unflowing or flowing at trial. And Judge Schreiber said, I've had this exact issue come up in other trials. I'm very familiar with this topic, and I'm going to sustain Judge Weiss's prior ruling to keep out the one question. We're talking one question. One question vitiated their right to a fair
It's a
trial.
Question though, counsel, isn't it?
It's a
I
real,
mean, think about it. If you've got a dispute with somebody, right? Let's say, you've got a dispute with Bob over there. You need somebody to referee that dispute. And there's 10 referees you could pick. One of them was his groomsman 10 years ago. You're not saying, I want one of the other 9 just to be safe. You're not thinking, I'm worried that referee's going to like him better than me or have some allegiance to him. You saying a jury couldn't look at that and say, it was 10 years ago, but I mean, that's a pretty close relationship, even 10 years ago.
I understand that when you retain experts, that was the factor with respect to Graham versus McKinney. I also hear you with respect to a general bias, but I also think you have to look at the totality of the record. You have to look at the fact that we have objective MRIs, objectively showing herniations, meaning it's not dependent upon anybody's word, whether it's a groomsman or not. You don't even have any opposition by the defense that the crash caused these herniated discs to enlarge. In fact, their radiologist offered.
Counsel, that sounds like a harmless error argument, but you didn't make one in your brief.
I don't know that they made a harmful error in their brief. for me
But
to
isn't it your
respond.
burden as
That's not the way
appellee?
briefing works.
Sorry,
Isn't it your burden as appellee under West Boca?
I understand that body of case law, but to be clear, I don't know that it was error. So then the harmless error. Bottom line is I don't believe that the judge abused her discretion, especially in the manner in which it was all presented in the.
Well, I get that, but assuming we do find it's error, we still need to analyze whether it's harmless error, right? That's another step in the process. And it's your burden. It wasn't raised in the answer brief. What do we do at that point? Did you waive it? Do we sua sponte have to look at that?
I do believe I briefed and quoted the Tran decision that talks about how it has to vitiate the right to a fair trial. One question in the scope of a lengthy trial with clear-cut objective evidence. I don't think Judge Schreiber abused her discretion such that it would constitute error. In my mind, when I equate error, I'm thinking de novo review as opposed to abuse of discretion. But number two, this was well after the testimony had been presented to the jury. They asked for a proffer, they're given the proffer. The judge analyzed the issue and said, I'm familiar with the issue. I'm going to.
As you said, it was after. I mean, it wasn't too late for them to ask Dr. Mahan about it though, right?
It was not too late in the sense that they were timely in asking for the proffer and the proffer was made. But by that point, the jury is now left for lunch and the judge didn't find it germane, given that there was already a discussion about friendships, that there was already a discussion about how defense counsel and Allstate had retained Dr. Mahan as their expert in their cases. So I do think that this issue of bias was fully flushed out. The one question that is remote in time, that is more than 10 years ago, now more than 11 years ago, but at this time it was 10 years ago, that doesn't vitiate their right to a fair trial under the Tran decision. That's my position with respect to that. Are there-
Counsel, could we, I
Yes,
want to go back to the discovery point. If we were to analyze this, this issue of his participation as your groomsman from a discovery standpoint, under 1.280, under the portions that you cite in your brief about what is permissible expert discovery, one of the lines of questioning is the identity of other cases within a reasonable time period in which the expert has testified by deposition or at trial. If in the course of asking that question, tell me all the other cases that you've testified in, and there are 100 Jeff Byrd cases and 2 for other lawyers, wouldn't it be an appropriate follow-up to say, why so many cases for Jeff Byrd? And depending on the answer to that, does it have anything to do with the fact that he was a groomsman at your wedding or something like that? In other words, the discovery is allowed into what other cases an expert has testified in. If there are some large number or disproportionate number for a particular lawyer, wouldn't it be within those discovery limits to follow up and ask why that was, explore all the reasons why that may be the case?
There was no discovery conducted on that point, so I'd be engaging in speculation as to what the response would be. So all I can say in a speculative nature is Dr. Mahan is one of the few radiologists in Central Florida. There are other radiologists who will read images in Central Florida, but they're outside the Central Florida area, most of them. Indeed, their expert, Dr. Negan, is from down West Palm Beach, Fort Myers. So is it any shock that someone who has an office here locally, who is retained by all of the local centers as an independent contractor, would read so many studies that I may thereby represent folks who've had MRIs read by him? That would have been the plausible explanation.
I don't disagree with that, that's a plausible and perhaps the correct answer to the question, but I'm getting at, you make the argument that if it's not discoverable, it's not admissible. And I'm just wanted to press on the idea that it's not discoverable to find out what cases a doctor has testified in. And then if it looks like there's a large number for a particular lawyer or on the particular side, plaintiff versus defendant, why it could not be, why further inquiry couldn't be made as to why that might be the case, which seems like it would open all the doors of potential bias that we're talking about here.
I don't think that that would be prohibited discovery, but it wasn't attempted in this case. I don't think that that opens the door, or otherwise we might as well throw out the Elkins decision, the Worley decision that talk about the chilling effect on treating doctors and patients having access to high quality treating doctors. If those treating doctors, the chilling effect is such that they no longer wish to participate in the legal process because they're tired of their personal life being made a spectacle of. People are allowed to have friends. Lawyers are allowed. I'm allowed to have friendships with judges and socialize and go to dinner and lunch with judges. I understand that somebody's going to say, well, what a groomsman is a different category. Okay, he was one of 10.
So that's the point. If you had a witness, everyone's allowed to have friends, obviously. But if you had a witness on the stand who was your friend, the other side usually ask, hey, aren't you friends with Jeff Byrd? Right? Like the friendship would normally be, why would that not be within the realm of bias? I mean, people are allowed to have friends, but they're not immune from questioning about it under the rules in terms of bias.
To be clear, that was not prohibited. That was not precluded by Judge Schreiber.
Yes, but the extent of it was, right? And, there are different things that can evidence bias, and they were allowed to ask about some and not others, and you're running square, and we've got a precedent on this. It's called Middlebrook. And it says that you can't evidence of one type of bias or one reason for bias is not a substitute for a different evidence of bias.
I see I only have 20 seconds. So to your point, again, there was evidence of bias. There was abundant evidence of bias. They weren't precluded from asking about a friendship. To me, and I realize I'm not sitting in your position as a judge, but it wouldn't be relevant if somebody were running a race together, a 5K race together, golfing together, play poker guys nights together. You are entitled to maintain a privacy with respect to your private life and private affairs, but it's not prohibited to ask, do you have a friendship outside the courtroom? And that wasn't prohibited in this case. I see I'm now over time. Does the panel have any further questions? Otherwise, I don't believe that Judges Weiss or Judge Schreiber, both very experienced judges, abuse their discretion in any respect in this case. I thank you for your courtesies today.
90.608 says any party may attack the credibility of a witness by showing the witness is biased. It doesn't have any limitations on whether or not you're a groomsman or you run 5Ks or anything like that. If it's biased, it's allowed to come in. As to the treating versus experts, State Farm versus German, 12 Southern 3rd, 1286 from the 5th DCA. Quote, a treating physician, just as any other witness, may be questioned at trial concerning any bias he or she might have for or against a party. Then goes on to say, quote, there is no logical distinction between treating physicians and retained experts for purposes of uncovering this type of information. The timing of the proffer really is irrelevant because there was a motion to eliminate granted before trial that precluded this evidence from coming in. There is no argument for this court that this was harmless error. And in fact, there's a tremendous amount of evidence that this was harmful error. Why? Because that Mr. Byrd specifically told the jury, hey, look, the defendant has retained this Dr. Mahan in the past. We didn't get to talk about the close personal relationship. Mr. Byrd argued in closing that the jury should believe Dr. Mahan because he was the top of his medical school and had been a defense expert in a case against Byrd. Again, this was a significant closing argument to the jury. And there's an issue that I admit is not preserved, but this court may consider it nonetheless in terms of cumulative error. And that is a probably a unique situation where Dr. Mahan was testifying. He was asked, when was the last time you testified in trial? And he said it was yesterday. In fact, there were people in the back room, and he's referring to jurors from that case sitting in the back of the trial that he is testifying in now. Those were the jurors in the trial that I testified in yesterday because the case settled after I testified. He is alluding to the fact that the jurors in some other case are so interested in what he has to say that they're going to come to a different trial to listen to what he has to say and suggest that they favored him so much that they went out of their way to watch him again, and they agree with him. That is significant, and I concede it was not objected to, but in the totality of the circumstances, which this court can consider in determining whether this had an impact on the verdict, that did. And I rely on the case Domino's Pizza versus Wiederhold, 248 Southern 3rd, 212 5th DCA 2018. In evaluating errors, we consider the cumulative effect of both preserved and unpreserved error. Very briefly, I do want to mention that at the hearing for the trying to get the cancer records, Mr. Byrd said it requires an in-camera review by the court. This is on page 318 of the record. The defense counsel said, quote, we should be able to look at these records. And the judge said, I'll look at the issue and get you all a decision on that. And then the written order says the medical records related to plaintiff's prostate cancer treatment shall be protected from discovery as they are unrelated to the accident at issue in this lawsuit and violate the plaintiff's right to privacy. So that leads me to believe that the judge wrote that because he looked at he looked at these records and said they are unrelated. So that issue is preserved. Your honors, we would respectfully request that this court reverse and remand for a new trial. And of course, we rely on the other arguments that I did not have time to get to that are in the brief. Thank you very much.
Thank you. We'll be in recess before the next case.